My superpower is engineering. I've been a roboticist almost all my life now. I think engineering is just as creative as the arts. Engineers, we solve problems. It impacts the world. It makes a difference. Without IEEE, I don't think I would have the network that I have. Anyone can get involved with IEEE USA at any time. There's an immense amount of value for anyone at any career stage.
Good afternoon, everyone, and thanks for tuning into today's IEEE USA Livestream webinar and our fifth and final in the Intellectual Property series in partnership with the United States Patent and Trademark Office, Patent Searching. I'm your host, Jonathan Cho. IEEE USA's goal is to create programming that is valuable, relevant, and of interest to you. We'll be sending a short survey to all registrants after this event and would love your feedback. We value your opinions and would appreciate it if you could take a few minutes and share your thoughts. Our presenter for today is Tamika Ubushan from the United States Patent and Trademark Office. Tamika has worked at the USPTO for over 15 years, serving in various roles from patent searcher to training specialist, and currently serves as the Eastern Regional Outreach Officer for their office in Alexandria, Virginia, where she supports the strategic plans and goals of the agency with focus on outreach and stakeholder engagement. Everyone, please welcome Tamika. Afternoon, Tamika. Glad to have you with us today.
Good afternoon, and thank you, Jonathan. I'm happy to be here today. Thank you all for joining us today. We're about to get started. And so let's take it away. Again, welcome to Patent Searching. So within today's workshop, we will cover the following. The benefits of searching, keyword of search versus classification search. What is a cooperative patent classification or CPC? The 6-step search process, and building a search strategy with keywords and the classification scheme. Now, before moving forward, please note that the information in this presentation is for informational and educational purposes only. You will see reference to patents, designs, trademarks, copyrights, products, and more. However, it does not imply any endorsements by the U.S. government, the U.S. Department of Commerce, the U.S. Patent and Trademark Office, or any other federal agency. Now, if you find that you have any questions, please feel free to write them in a chat, and we'll look at these questions throughout the presentation where relevant and at the end of the presentation. Let's get started with what is actually a patent. So a patent for an invention is the grant of a property right to the inventor issued by the United States Patent and Trademark Office. Now, it excludes others from making, using, selling your invention within the U.S. or importing it. Now, for a limited time, generally the term of a new patent is 20 years from the date on which the application for the patent was filed in the United States, or in special cases from the date an earlier related application was filed, subject to the payment of maintenance fees. Now, the U.S. patent grants are effective only within the United States, U.S. territories, and U.S. possessions. Under certain circumstances, patent term extensions or adjustments may be available. Once a patent is issued, the patentee must enforce the patent without aid of the USPTO. Now, there are 3 types of patents. Utility patents, which may be granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement thereof. Also, there are design patents, which may be granted to anyone who invents a new, original, and ornamental design for an article of manufacture. And there are also plant patents, which may be granted to anyone who invents or discovers and asexually reproduces any distinct and new variety of plant. Now, the term article of manufacture encompasses both a product sold to a consumer and a component of that product. And it has a broad meaning. An article is just a particular thing, and manufacture means the conversion of raw materials by the hand or by machinery into articles suitable for the use of man, and the article so made. Now, moving forward, we're going to take a deep dive into why search? Why not? First and foremost, you must determine the patentability of your invention. Consider whether it is new, novel, useful, and non obvious. But how do you know if an invention is that? That takes us to this next slide. Now, first and foremost, you see we're on step 2 of the patent process, which explores, how to determine if our invention or your invention is patentable. You've already determined that what type of intellectual property protection is needed, and that's for patents. And now we're going to move forward to take a deeper dive into the patentability aspect. So to ensure that your invention is indeed something new, novel, and non-obvious, you would conduct a prior art search prior to filing your U.S. patent application. You can start with an initial search of U.S. patents and published patent applications. Also, conduct a keyword search, but be mindful that you should expand your search with additional terms. And include a supplemental prior art, meaning anything publicly available or disclosed to the public, search with a classification search of granted U.S. patents and published U.S. patent applications. Also, conducting a thorough search helps with determining the patentability of an invention. Now, here we are with prior art. So for those of you who do not know, so prior art is any document that contains a discussion or description relevant to an invention for which a patent is currently being sought or enforced, and it may be a prior art reference. Now, it is an applicant's duty to submit to the office information which is material to patentability of the invention claimed in a non-provisional application. Now, a patent examiner may reject one or more of the claims in a patent application on the grounds that they are anticipated by or obvious in view of the prior art. Next, we're going to move forward to some examples of prior art. Now, prior art consists of information disclosed to the public, including any foreign patents and published patent applications, U.S. patents and published patent applications, books, magazines, journals, websites, you name it. You can see from this list, it's not exhaustive, but it is a list of what is considered prior art. Included in this also are scientific papers as well as conference proceedings. Now, in reference to keyword searching, there may be some challenges that you should, you may encounter, or there are definitely things that you should take into consideration, such as vague or inconsistent terminology. For instance, toy and process of use. This is a reference here, for example, or obsolete names and terms. For example, LP or hi-fi or laser desk or water closet. I'm sure some of these ring a bell for some of you. And also for consideration, different meanings in different fields. For instance, mouse, the animal, versus a computer mouse. Or a synonym, for example, a rodent extermination device. These are just a few examples. But I have more. Some additional examples include color versus color, which are the text British spellings. For instance, the use of the word you in color versus color without a U, the English version. Tire versus tire. Also for consideration, spelling errors and variants, repellent versus repellent, three-willed versus tri-willed. Any acronyms and abbreviations such as LED or light emitting diode or PDA for personal digital assistant. Now moving forward, there are some challenges to keyword searching, including some text patent databases with limit keyword searching to no earlier than, for example, in Google Patents, we have the 1800s. Also for the USPTO's public website, going back to the 1830s, and also for Pub East and Pub West, 1971. And searching by classification, please note this, also allows access to all US patents. Now we're going to move forward to what is classification. So here we have an image of a file drawer system for organizing tools or various parts for building things. You can see that the items are categorized and organized in a certain manner. Now, in general, a classification system is a system of hierarchical categories used to organize like things by their characteristics and relationships. Now, classification systems are great and extremely useful for sorting and searching large collections of information, including inventions. Now we're going to move forward and take a look at the world classification systems. Now, what you see before you are a list of the classification systems, including the USPC, IPC, ECLA, FI, and CPC. Now, each one of those offices are classified into various systems. For instance, USPC, it's the USPTO, IPC, union members, also FI is the Japan Patent Office. And you can see that there is a relationship to the IPC listed here for each column. You'll see for USPC, there's none, as well as IPC, but for ECLA and FI and CPC, you can see the relationships to IPC listed here in this chart, and also other information related to the classification types and the rules for classification, as well as the number of subdivisions. Now, the focus today will be on CPC classification, which is an extension of IPC, and also it has 200,000 subdivisions. So we're going to move forward. Okay. Now, what is CPC? Now, it's a joint partnership with the APR, European Patent Office. There's the harmonization of the USPC as well as the ACLA classification systems. And the CPC is divided into 8 main areas. And for instance, you can see here the areas here from human necessities to textiles and paper to electricity. And again, here are examples how of the 8 areas in which the CPC system is organized into. Now, moving forward to the 6-step U.S. patent search strategy. Now, this strategy for searching U.S. patents and published patent applications is used to locate and evaluate prior art that's relevant, right? So any previous publications that discloses an invention would preclude any issuance. Now, a more comprehensive prior art search would also include foreign patent publications and a non-patent literature. It's really important to note that recording of your search process, including any databases that you use, the date, time of your search, the classes searched, and any patents published and patent applications retrieved. It's really important as part of your search process. So please be mindful and make note of this. Okay. Now, we're going to really get started here, taking a deep dive into the actual search. And here we have the search example. And the search example before us is the umbrella. All of you can identify with an umbrella. All of us can identify with an umbrella, right? So we have invented an umbrella with a new rib design to eliminate the umbrella from collapsing or inverting due to winds. And I know we've all been there at some point in time or another where we're caught in a storm and our umbrella just gives out on us, taken away by the wind. So starting off, step 1, brainstorm the terms describing the invention. So get your notepad out, or if you're working from your computer, and start brainstorming about, what is the purpose of the invention? Is it a utilitarian device or an ornamental design? Is the invention a process, a way of making something or performing a function, or is it a product? What is the invention made of? What's the structure of it? How is it being used? Think of those key words or any technical terms that also describe the nature of the invention. And please be mindful, use a technical dictionary or thesaurus to help you, expand on those initial terms or keywords that you come up with in planning and brainstorming for your search. Now, thinking about our particular search example, this portion considers the area of brainstorming when describing the invention, right? So the purpose, invention components, how it's used in other terms, all come into play. For instance, for the purpose, again, the umbrella has a new rib design to eliminate the umbrella from collapsing or inverting due to high winds. Now, the invention is an improvement in umbrellas to eliminate the need for frequent replacement of umbrellas. Now, the components, the framework, consider that with ribs, stretchers, a main frame, securing rings, mounting brackets, joint connectors, and fabric linkage, the fabric linkage bar. Now, how it's used is needed in protection from the elements. Now, other terms now, in addition to the above, consider parasol, sunshade, support assembly, or apparatus, windproof and wind resistant. I hope you're all taking this all in. So we're moving forward to step 2 of the keyword search. Now that you've gotten all of your keywords and synonyms together or thinking about that, you want to also take into consideration the use of Boolean operators. Using or to group together synonyms, and using and to find the intersection of 2 sets of information. And remember, they're in caps for a reason. So please remember in your search when you're using these Boolean operators to use all caps. Also consider including wildcard symbols such as the asterisk to obtain versions of words. And so we'll go into a little more examples you'll see here soon. Incorporate quotes also to group search phrases where words are adjacent. That's really important. And also consider filtering by selected fields, like the inventor name and so forth while you're searching. Now here, we're going to take a look at our search strategy. First of all, we've got the use of the word umbrella, using the wildcard asterisks, right, to get variants of the name or plurals. Also, we're using or, the Boolean term, in caps, along with another keyword, parasol. Again, taking into consideration the use of the wildcard symbol, the asterisk. Also, again, using or as that connector to the next keyword, sunshade, again using the wildcard. And notice that these are also in parentheses together. So we've grouped those like terms together. Then we've used and, the other Boolean operator, in all caps, to combine the next grouping of terms, which includes windproof or, in quotes, wind resistant. And again, with parentheses, bringing everything together under one keyword search strategy. Now that we have that, we're on to step 3. Conduct an in-depth review of patents you selected based on your initial information. So you would review each U.S. patent you selected that are similar to your particular invention. In this case, we're using the umbrella. Look at other sections of the patent, any drawings, any specification, and also the claims that you'll see on some example patents that you're looking at while you're researching for your particular invention. It's also important to review any references cited by the applicant and or a patent examiner, which may lead to other relevant patents. Now, save the most relevant U.S. patents that you find. So this will help you along the way, and refine and repeat your searches. Now, for example, I just referenced taking a look at a patent application and looking at the references as well as any claims. And here we have an example of patent, a U.S. patent. And again, reviewing the front page of each patent and the drawings as well. And you can record the patent number that are similar to any inventions that you come across so that you can take a closer look at those. Now, note in this particular view, you'll see here that the CPC code is highlighted here. You'll also see a reference to other codes. For instance, there's the USPC, but our focus will be on the CPC code listed here. So we have A45B and then it's like 19/00. And then we have A45B 23/00. And again, we have A45B 25/02. Now I'm going to move forward and show another image. Now this is another U.S. patent application for reference, and again reviewing the front page as well as any other relevant pages, and again recording the patent number to any similar patents to your particular invention. Now for this particular example, you see the U.S. classification listed here, 135/31 for the USPC. But there are no CPC values in this particular example. Again, now for this particular example that you see here, we have the corresponding U.S. patent text version. Now in the text view, any issued patents before 2015 will contain both a US and CPC values. Now, those CPC values, they have been retrofitted to all US patents. Now, since January of 2015, the US patent images contain and display the CPC values. And you can see here in this example here, again, referencing one of the examples from our initial application shown, A45B. We had the same CPC class listed there as well, but two other sub areas featured. Okay, let's move forward to step 4. Now, step 4, where we will retrieve and review any published patent applications using those CPC values noted in the application. Now, for instance, the prior example shown, we had A45B25/22.cpc. Now here you'll see a screenshot, and all of the databases selected are the USPG Pub, US Patents, and USOCR. You'll see that the default operator is OR, that's our Boolean operator. All of the other boxes checked indicate any errors or plurals, and also British equivalents. And you would just simply hit search. Now, going to step 5, the cited references. So you would take the time out to conduct a search of any of the US patents and patent applications that have been cited in the applications that you're reviewing. Okay. Now for step 6, this is where you would broaden your search. Now you can broaden your search by extending it to searching for patents and published patent applications, of course, again, using the CPC classification. And also rerunning your search using a SPOSNet, and that's the link there. I'm sure my colleague or someone will put in the chat for you that link. Also, you can search for non-patent print electronic publications, any of the ones we mentioned earlier, conference proceedings, journals, magazines, websites. In addition, and you can always hire a registered patent attorney or patent agent to review your search and conduct a follow-up search of his or her own. Now, in order to access the CPC set schema, you would go to the USPTO.gov homepage, and then from there you can search for a CPC classification. We have a search box located in the upper right hand of our website and on the homepage. And from there you can use specific language for your search terms within the CPC interface. For instance, we're searching for the umbrella, right? And from the search results page, you would click an entry for a class, subclass, scheme page. Now, if you're not satisfied with your results, you can rerun your search using synonyms identified in our step 1. So here is the screenshot of our web page, and you can see in here in the upper right-hand corner, you can type in your keywords here, or here you're looking for CPC scheme umbrella. From there, you'll see an initial list of results, the results page here, and you would select from the list for CPC. Then you'll be taken to another screen. You'll actually be taken to the Cooperative Patent Classification Interface. And from there, you can see from this example, we mentioned A45B. And this takes you directly to the classification for walking sticks, umbrellas, ladies or like fans. Now, doing a close-up of this, and if you would scroll down the screen, you would see here specifically in referencing the patent application that you saw a few screens ago, A45B 25/22, and that specifically references devices for increasing the resistance of umbrellas to wind. And that's what we're looking for, right? So this is the example here, and you can see clearly from this listing here. Now, I'm going to move forward. Now, to access the classification definition, you would select D to the left of it, and in the previous screen there was a D to the left, and it's hyperlinked to the CPC definition. Now, those are helpful so that you'll know the scope or the relevant classification that you're searching for. This instance, we know it's the umbrella, and that's A45B 25/22. And also it includes some images, but not most include images, but most include text when you look into the CPC definitions. But in this case, we have images. So from here, you can see that this place covers this. You can see this is kind of like the structure internally for the umbrella listed here. I don't know if you can really see this clearly. And also the other figure here for the cover. And also you can see another example for an umbrella here. And notice the points of the arrows are pointing to the increasing the resistance of umbrellas to wind for each one. Now for search resources, we have a list here of some external ones that may be of use and very helpful to you in your process of searching. And that includes, of course, Google Patents, ESPOSnet, Patent Scope, also free patents online, as well as the CPC site in general. And also within the USPTO, you can search for patents as well. And we have an additional set of resources also available through the PTRC. Now, the PTRC, you may ask, what is that? They are the Patent and Trademark Resource Centers. It's a nationwide network of state, academic, public libraries, and they're, at a location near you. They're located all across the U.S., and the librarians there are there to help you with searching and any informational needs in regards to patents and trademarks or all types of intellectual property. And you can visit our website, uspto.gov, to find out more information about the PTRCs. Now, moving forward, we are on step 5 for preparing and submitting your initial application and the patent process, that is. Now, we have the Inventors Assistance Center, or IAC. They provide patent information and services to you all. It's staffed by supervisory patent examiners, or SPEs, and experienced former primary examiners. They answer any general questions concerning, the patent examining policies as well as any procedures. And they can be reached Monday through Friday from 8:30 a.m. to 8 p.m. Eastern Time, except for federal holidays. And there are a number of, there's a listing of numbers here that you can reach them. We also have the Electronic Business Center, or EBC. They can assist with a number of things, including, viewing your application information, any web issues that you're experiencing, submitting your patent application, or any issues that you're encountering with your patent application, or any technical problems as well. They're also available Monday through Friday, except they're a little earlier, from 6 a.m. to midnight, except for federal holidays. You can, in addition to reaching them by phone, you can also reach them via email at ebc@uspto.gov. Now, for USPTO resources, there are many available on our website, including the Path to Patent, which is a quarterly series offered throughout the year. And we cover everything from intellectual property basics, including what you have here, patent searching, anything that you need to understand about filing applications, everything that you would need to know. So please check out our events page to see when the next set of trainings are available for the Path to Patent series. And now I'd like to turn over the presentation to my colleague, Tom Turner, who's a librarian at the at headquarters at the USPTO for the PTRC, where he will cover our new search tool. And Tom, please take it away.
Good afternoon, everyone. Patent Public Search is our newest patent search tool. It's been made available since February, and it is taking the place of the current the search tools that have been up there for about 20 years, PAT-FT, which is called Patents Full Text and Image Database, and AppFT, a separate one for published applications. Well, what we've done is with this new search tool is we've combined all that. We've based the new search tool on something called Patents End-to-End Search, which is used by our patent examiners, and it has many, many of the features that the search tool that the patent examiners use. From the homepage of the USPTO website at www.uspto.gov, as you see in the top image there, if you click on Find It Fast, a drop down will give you some choices. And under Patents, there it is, Patent Public Search. It still gives you the links to PAT-FT and AppFT, but they're going away after the end of September. So this is a good time now to transition over to Patent Public Search. You see below, in the image below, you see the landing page for Patent Public Search, and you can click on the button that says Start Search. When you do that, we'll go to the next slide. The next slide shows you, this is showing you the default format for the advanced search format. Notice in red, we've highlighted that you either have quick search or advanced search. Not large differences between them. The quick search has 3 panels. The advanced search has 4 panels. In advanced search, all of the features of Patent Public Search are activated, including tag documents and notes viewer. This is the one that rather than having to activate things that are not activated, this has all of the features right there. Now, all of these panels, this may look intimidating to you, but all of these panels can be customized in size, and you can collapse a panel. You can actually drag the features from one panel to another. So it may look like a lot, but you can customize it to your needs of whatever laptop monitor that you are using. Now, in our next slide, notice right here these panels. In the middle there, we have the search panel. And in the next slide, we're showing you the conducting of the search that Tamika was showing you. The one about umbrella, synonyms to umbrella, and windproof or wind resistant. The searcher clicked on search. It conducted the search, and the search results are in the panel below that. The search history is saved in the panel on the left as a search statement, as an L number. And that means you can take those results from that search and combine it perhaps later with another keyword or with a classification, just using the L number. The search results panel is kind of sneaky because it only shows you a portion of the search results, but of course it can be expanded. If we were to expand that panel, we would find there are actually 18 columns there. You'll notice by the document IDs that there are little check boxes. Those check boxes allow you to tag any documents of interest. Why is tagging important? Well, as Tamika mentioned to you, as you're going through this 6-step process, during one of the steps, as you scan the front pages of patents, you can select patents. You can tag those of interest and then look at those selected patents later in closer detail, looking at the rest of the patent. So there is a way with Patent Public Search to tag patents of interest and then look at them in the Tag Documents viewer. If Tamika will highlight next to the document viewer, we have the Tag Documents viewer, and only those documents you tag will then appear in the Tag Documents viewer. The other thing I want to point out in this particular slide is you notice in the document viewer, it's showing us the very first document that we have viewing. What we're viewing right now is the full text view. And we have selected the K button, and that's showing you keyword and context. Only those words that were in our search what we're doing is we're pulling only those paragraphs where those words appear. I mean, just think about it. Patents can be 100 pages long, and this is a very powerful feature because it allows us to look for to see what how those keywords appear and to find out whether or not this patent is indeed relevant to the invention that we have considered. Now, you see, we're again looking at that K button. To the left of that K button, over at the very end, at the far left, there is a button it looks like a T with a camera. That's a toggle button. It will toggle back and forth between the full text view, which is what you're looking at, and the image of the patent, the PDF image of the patent. So it's there. And of course, we want to be able to see the drawings, right? So that's the way you would get to see the drawings. And Tamika, let's see, our next slide is, so you're going to go into the resources. But I want you to be aware that we do have training into the doing a deep dive into using the features of patent public search. We have, if you go to our USPTO events page, we have 2 coming up. One tomorrow, an introduction and overview into patent public search that will be running at this same time from 2 to 3 and Eastern time. And then on Friday, a look at the advanced features for frequent searchers in patent public search. And that's the presentation that goes into such things as tagging documents and the ability to write notes to yourself as you're going along and doing extensive searching. So you might be interested in those. We offer those presentations. We offer 2 webinars a month. It just so happens that the ones for August are coming up tomorrow and the next day. And if you look at the events page, you'll see the ones that are coming up for September and so on. So now I'll pass the baton back to Tamika.
Wonderful. Thank you so much, Tom, for that overview of the patent public search portion. And now just to share a little bit more, in addition to the path to patent and also the searching aspects of searching patents, we also have the Trademark Basics Bootcamp, where there's also an opportunity to learn more about searching the trademarks database, including tests. And so, again, for your awareness, thought we would bring this to your attention as well. And please, at this time, if you have any questions, the virtual floor is open, and we're here to answer questions. Thank you.
Fantastic. Thank you, Tamika and Tom. So folks, we are at the Q&A segment of the webinar. Please post your questions in the comment section and we will load them onto the stream for our presenters to answer. So Tom, Tamika, before we move on to our audience questions, I did have a few of my own that I would like to ask. I guess either one of you, if you have an answer, feel free to jump in. But this question specifically for first one for Tamika. So you've worked as a patent searcher in the past, and so obviously you've done plenty of patent searches yourself. In preparation for a patent search, is there anything that you needed to do have to prepare beforehand? Like, did you have a checklist of things that you want to make sure that you had before you do the patent search?
Absolutely. Great question, Jonathan. Yes, in my former role as a searcher, I did have a checklist that I would work from for each search. Definitely had in my searching toolbox my sheet where I would come up with of course, the keywords, synonyms, looking at the thesaurus, looking for additional keywords. Also setting aside time to really map out which databases I would use for searching. That's really critical as well. And making sure I looked at references and things of that nature, doing a really, planning thoroughly before actually going into the search itself. So yes, I did have a checklist. Great question.
Awesome, thank you. My next question, So you've mentioned a lot about specific strategies for searching for patent searching. Uh, Boolean searches. If anyone's ever done a Boolean search, you know how much that can help when you're searching for anything on the internet, as opposed to just specific words.
Mhm.
You've also mentioned how being too specific cannot be very good. Typically, I guess you want to be as broad as you can. Uh, what are some other, or what are the biggest pitfalls to avoid when conducting a patent search, would you say?
I would say that you want to make sure that, again, and you've already highlighted something, you don't want to just consider, okay, I've come up with a few words and this is it. You want to make sure you do broaden your search. And then as you're going through the search experience, if you will, begin to really narrow down your search based upon your search result sets, right? So, for instance, Tom shared with us within the patent public search view, you have the L numbers, right? You have your first set and then your next set of combined terms, and then bringing in the CPC classification. You want to make sure that you really start out broad and then narrow down to really get to seeing whether or not you can find any prior art. So making sure that you've covered all your bases uh, with your search strategy, definitely your keywords, synonyms, um, just making sure you're not just like, okay, I think I'm done. I've done enough. Because you don't want to just file, put in for an application and then you're like, oh, it's been rejected. Oh, because guess what? The search wasn't thorough enough. And so it's always good to, if you're not super well versed in searching, or you feel that you need some additional support in that area, again, reaching out to a patent attorney or agent would be great, if needed. But I think that's the real, the primary thing, just making sure to avoid not, doing the best search possible.
Gotcha. Thank you so much.
If,
And
if I could,
oh,
if I could just add something there. I mean,
absolutely.
one of the challenges, and I know we're not telling anything that the people in our audience don't already know, but the challenges of working with patents is the language of patents. I mean, it's this mix of engineering language and legal language. So
Mhm.
common everyday terms for words. I mean, Tamika had some great slides that showed you that the words that the average person on the street would use to describe an invention may not show up in a patent. So that's why there's kind of a danger in relying just on keywords. And we strongly urge that if you do start off with a keyword search, if you find relevant classifications they keep showing up as it did with that umbrella, use those classifications because you're likely to find more relevant patents by expanding your search from just keywords to relevant CPC classifications.
Great insight. Thanks for that, Tom.
Mhm.
So we do have folks. We did get a couple questions about if we can send those links out that was shared during the presentation. So I would like to mention that I've linked all of those links in the comment section, but we'll also provide them in the follow up feedback email that we send after this webinar.
Sure.
So yeah, Tamika and Tom. So questions from our audience. First question. Again, feel free to jump in. Chris asks, "What's the best and most legal way of recording your searched patents during a patent search?"
Hmm. Another great question. The best. Um, Again, we're
I can
here to
comment on
give
patent
legal
public.
advice, but I
Oh,
mean,
yeah,
go
that
ahead,
word
Tom.
legal scares us. Don't do
Right.
don't do that. Let me,
Yes.
but let me comment on the use
Sure.
on recording things with patent public search, and
Yes.
that is you saw in the slide that Tamika showed you. You have a panel that lists your search results, and those are multiple columns. And we have a quick reference guide that's available from a reference section of Patent Public Search that kind of goes over this. But what you can do is this: you can highlight a column of any of the search results, such as the patent numbers. You highlight the column, do a right click, you can copy, and then separately you can paste those results in an Excel spreadsheet. And it can be any column in the search results if you hold down your control key. So you might want to do the document ID, the inventor name, the assignee name, classifications, whatever you wish. That is a feature available through in Patent Public Search in the search results column.
Awesome. Thank you, Tom. And we do also have another tip from Albert Wong, who's helping us from behind the scenes from the USPTO.
Yes.
Patent examiners typically print out their search history and make it part of a file. So, that definitely printing everything, all your documents out is a good way of keeping it recorded um, when digital searches or files or anything may not always come in handy.
Yeah. And you can also have your inventor's notebook or that you keep track of when you're searching. And again, to Albert's point as well, and to Tom's as well, just keeping a printout or electronic file. But that notebook is also a good source to keep track of your ideas and the search strategy as well.
Mhm. Thanks for the question, Chris. So this next question, I think we kind of addressed it in our previous question. Who should do the patent search, the inventor or a patent attorney? We've been warned there are potential liabilities if the inventor does the search. So I guess just briefly recap your recommendation on that.
Uh, Again, I mentioned earlier that you can definitely reach out to a patent agent or attorney if you sense that your search isn't really resulting in what you thought you would find, or if you feel most comfortable reaching out to them as opposed to doing the search yourself. But if you're confident enough to say, "Oh, I've got this covered," then really the decision is up to you.
Mhm. Definitely.
You have options. Just think of that. You have
Yeah.
options.
Probably, I would probably say hiring a professional who does this is probably the best way to go about investing in with your time. So
Yes.
yeah, thanks for the question, John. This next question, George asks, are people's search terms or searches accessible to anyone, and can others see people's search ideas? Are searches confidential?
Hmm. That's a really great question. I haven't received that one before. I'm not aware of,
Yeah,
in
the search.
general,
Yeah,
people's search terms. Go
the
ahead,
search.
Tom.
The searches are confidential.
Yeah, I
This
wonder.
is using the HTTPS protocol. They're not. They are not. Uh, they
No.
are not. They are. They are private. They're not. And in fact, when you end your search, it will wipe out the search, and that's
Yes,
why it's
that's
important. Because because there is no way to save your workspace and then go back to the search again. So you'll want to do such things as we discussed, making as was mentioned, to make a copy of your search statement, make a copy of any relevant patents. If you can, download
mhm.
uh, the patent numbers if you want to further your searches later date, because it's going to wipe out the results when you're in your search.
Yes, that is correct.
Awesome. Thanks for that, Tom. And thanks for the question, George.
Yeah.
1 second. So we also got another tip regarding patent searchers and who should be doing patent search. There is no requirement to do a search, but it is important to disclose all relevant documents found in a search. Failure to disclose relevant documents can have negative consequences.
Mhm.
So yeah, thanks for that, Albert.
Mhm.
Next question. We have a two-part question, or two questions. Stefan, I hope I'm saying that right. Patent I'm considering filing is for a process. How do I determine if it falls under a utility or design patent?
Let me share.
Well, a process is going to is one of the categories of a utility patent. But just to remind you, the differences between the two: utility patents protect how something works. Design patents protect how something looks. You may have one invention that has a unique look, but also it may qualify for a utility patent. But in the categories that we have at USPTO for utility patent, processes are under utility patents.
Awesome. Thank you, Tom. Thanks for the question, Stefan. So actually, we'll move on to second question. The patent I'm considering filing is based off formulas from notes in college courses. Would I reference the course notes, or is it considered common knowledge? Ooh, Tomika, I think we've lost your audio.
What's the patent? This is a really excellent question. Can I follow up with you, Stefan, on this particular question?
Yes, Stefan, if you would like to reach out, we can give you the contacts for the USPTO so that you can reach out to them for your questions. Same for any of our audience members as well. So we'll include that in the feedback form as well. But thanks for the question.
Yes.
Very complicated, but very, very good questions. Thank you. Thank you, everyone. Next question. Robert asks, I was doing a prior art search and found competitor that listed patents by application number. I could not find these patents. How do I convert an application number to a searchable publication number?
Well, I think there's two things to think about here. One is while you have an application number, if it's an application that resulted in a published application after 18 months, there will be a published application number, which is different from the kind of the serial number. The serial number typically has a series code of 2 digits before it, and a dash, and then an application number. That's the number that is given an application when the USPTO accepts the application. Then, if it results in a publication, a published application, that will start off with a 4-digit year and then a number. Those are usually included on the front page information of a patent application and later the patent. So it's a matter of if you look at the fields that are involved, and if you do have that original application number, then you should be able to go forward with it. Another thing you can try to do, we now have moved over a public pair over to the platform of Patent Center. That just happened about a week ago. So you can put in that application number and it will pull up if it is publicly available. And that only happens once you get that 18th month publication of the application. If it's publicly available, you'll be able to look at the image file wrapper on that particular application. So it's not so much conversion uh, from one to the other. It's the fact if you look at the file on that, and that information is put on the front page of patents and published patent applications, you should be able to get the publication number. Tomika, any comments?
Thanks for that, Tom. That was spot on. I was putting some information in the chat, so pardon my silence. So thank you. Yes, that's perfect.
Yeah, no, thank you for the question, Robert, and thank you, Tamika and Tom. I guess this is why hiring a professional for this is very important, so that you can avoid running into these obstacles, right? So this next question, John asks, what fraction of applications are accepted on the first round these days? If you had to guesstimate.
I am not a patent examiner, so I'm not. I couldn't speak to that,
Mhm.
and I'm really not sure. But it's a great question. Uh, Perhaps my colleague Albert can put in the chat if he has any feedback in reference to John's question.
Yeah, I mean, I guess it would definitely vary. One
Yes.
thing's for sure is that if you do a very good enough search and when before filing your application, you won't even have to worry about that because yours will possibly probably get accepted, hopefully. But we do have Albert who told is telling us about half of all applications will issue as a patent. That's good to know. Oh, about 50%. That's good a number. Thanks for the question, John, and thank you, Albert, as well.
Yeah, I think the key here is his question by saying first round. And my
Mm,
understanding has always been that patent examiners very rarely approve a patent without, uh, you know, giving an office action on it based on the prior art search and what have you. And that just simply it's very unusual that it would be accepted up front on the quote first round.
mm.
And then not to feel bad, that's typical of almost every examination of a utility patent.
Right. And apparently, a lot of applications will receive an OPAP notice for deficiency in the applications. Most can be corrected. So that's good to know as well. Even if it doesn't go through the quote unquote first round, the applications can have the opportunity to be corrected. So thank you for that. So we do have a few more questions. If Tamika and Tom, if you are okay with staying a little longer to get through the rest of our questions. Um, let's see. Steven asks, since patents can take up to a few years to publish, how do I cover the new material in my search to not be scooped and lose my investment?
Well, I think if you look back at the patent office didn't start publishing patent applications until 2001 with a change in the law. And when they did that, they uh, part of the writing of, and I can't provide legal advice here, but I'm just saying part of that law was that if and this was a concern, particularly of independent inventors, that if you have that application out there, and what if somebody copies it, and therefore the understanding is, and please follow up on this with an attorney, but the understanding is you can turn around if a patent does issue from that and someone has copied that disclosed information in the published application, you can turn around and sue them for any profits that they made from that. That was built into the law when they made that change. So, because that was a concern of, like I said, because this was such a big change, because never before were we publishing applications. They were doing this in other countries, but they were not doing that in the United States. We also give applicants an opt out when they file their application. If they don't want their application published after 18 months, they can choose to opt out of publication up front, but they have to say that they're not going to file elsewhere in the country that has 18-month application. So in that case, if it does not result in a patent, it will remain secret.
Great, thanks for that, Tom. And we would recommend that you file as early as possible because you can file a provisional application as well. Thank you for that, Albert. And thanks for the question, Stephen. James asks, if you have a CPC code and search on that, is it necessary to do a word search?
I think it's just important to cover with a word search and also combine it with a CPC code search as well. And you can see that I still have the slide deck up with actually where you can see the combination of terms and the L numbers. But I think it is necessary to do so. Again, you want to cover all your bases. You don't want to leave any stones unturned, right? So
Definitely, for
I
sure.
say definitely.
If you're going to do a search, and especially with something as important as a patent application, which some people have stated takes quite a bit of time, I feel like you should invest in as much effort in this search as possible before doing it. So is it necessary? Yes, since applications may not be classified properly. So thanks for the question, James, and thank you, Tamika. This next question, how do we determine whether or not a patent has been maintained?
So what we mentioned a few minutes ago, Patent Center, which is on the USPTO website. You can go through the portal called My USPTO, establish your own account for free, and then you can look up any application number or patent number, and you can check on whether on the whether the maintenance fees have been paid, or if it is, or maintenance fees are paid the 3.5, 7.5, 11.5 marks during the life of a patent. But if those maintenance fees aren't paid, then that patent will expire early, and so and then is in the public domain. So that's one way you can do that by checking through the patent center. We're taking the process that you at one time you could find in public pair or a maintenance page that were separate, and now they've combined all this stuff into something on USPTO called Patent Center.
And folks, we have provided a link to the Patent Center in the comment section. Again, we'll send all those links out in the following email as well. Thank you, Tom. Also, quick question about that. Can you also see a patent's previous versions on there as well? Or I guess one of our audience members' questions is, what's the best way to see a patent's previous versions, if not through the Patent Center?
Well, if you'll notice, for example, in this still slide we're still showing up here, under the search results, in the second column, one of them has a +2, and that has a plus column that's pretty much empty until you get to about the seventh entry there, and it has a plus. Those, if you click on that, that will expand to the family members. And so that if this is one way to one of the features of patent public search is it filters results by family. So a way you can look at family members, we're talking about applications, the granted patent, there may be continuations. We're talking about families within the US, not families of filings overseas, because this is only a US database. But that is certainly one way you can find that. You tend to find that information on the front page of a patent. If they go into long histories. If it says this is continuation of application such and such, but this is one way, a nice way, built into patent public search that allows you to see other family members.
Great, thank you, Tom. So, folks, we have just a couple more questions. I know we could go on about this all day. Definitely nice to see that people are interested in filing for patents. Um, and you can definitely find all information and documents on that through the USPTO website as well. So, this question, sorry, getting through all of them. Kenneth asks, how do you choose a patent agent or an attorney? And how many are there in the USA? If you know the answer to that, number wise, what are the nominal fees slash charges, and are there USPTO recommended patent attorneys and agents?
Another great question. I actually put in the chat. So if you see me go silent, I'm actually putting some links in the chat along with my colleague Albert for finding a patent practitioner. And you can see from that list, there are lists of various patent agents as well as some disciplined practitioners listed there and information in helping to find these registered patent practitioners. There's an active list, a link to that there through our site. So please reference that link. And I'm not sure how many there are, but if you would check out that link, it probably could give you an idea. In reference to fees, I believe they would vary by attorney because no two attorneys or law firms are like, I'm sure. And again, not necessarily anything that's recommended, but through our website for finding a patent practitioner, it's a great tool to find those who are registered, not necessarily recommended, but registered.
Fantastic. Thank you, Tamika. And again, folks, all the links are in the comments section. So there's a lot of them. I understand. We'll make sure we get all of those to you afterwards as well. So our last question, Eric asks, can I get a patent for a different application for an existing product?
Oh, these are some really fantastic questions. Perhaps my colleague Albert might want to speak to this or put something in the chat. And he has. Thank you, Albert.
Yes, a new method of using an existing product can be the subject of a patent. Thank you for that, Albert. So there you go. Thank you for the question, Eric. So, folks, we are out of time. Really appreciate you all tuning in. Tamika and Tom, really appreciate you and thank you for sorry. We really appreciate having you both with us today and providing your insight into patent searching tips and search tools for our audience. Really, really great to have you both with us. Tamika, I think you're
Thanks, Jonathan, so much for having us again today. And thanks to my colleagues, Tom and Albert, for joining in today and supporting this webinar.
It's definitely thank you to Albert, who you all can't see, but we can joining us backstage. Really great helping us in behind the scenes. Thank you, all three of you. And thank you to our audience for tuning in for your great questions as well.
Yes.
As mentioned at the beginning of the webinar, we'll be sending a short survey to our registrants after this event and would love your feedback regarding this webinar and our intellectual property series as a whole in partnership with the USPTO. Please like and subscribe to our channels. Check back daily on our social media for future live stream updates and hope you all have a great rest of your day.
Take care.